Hello, it's Chayah Shalom. Well, I feel so much better. Oh man, it was like, I don't know, 2.5 weeks of having the flu. That thing knocked me out. That was bad. And then I had to end up just cleaning the whole place and catching up on laundry and dishes and, you know, vacuuming and all that kind of stuff because it was, when you don't feel good, you just can't do all that kind of work. That's like heavy duty stuff. But I will say that the Pedialyte really helps. So if you ever feel like, you're losing, what is it called? Electrolytes and you need more energy, Pedialyte, that seemed to work. I had to one time get a Gatorade. I don't suggest getting Gatorade because of the Cenomix that's in it. But anyways, I am back to reading again. Okay, so I need to look. What are we going to do? Share the screen here. Let's see. I went on YouTube. I don't know. I think I was on TikTok and then it went to YouTube and then what did I do? What are we doing here? No, we don't want to share this stuffs. And no, we don't want to share that. No, we don't want to share that. No, we don't want to share that. Oh, here we go. I think we want to share this, but now I don't know if I'm sharing the right thing. So I have to do that. All right, where are we? Share screen. Yeah, I got to get with the program, man, because, hey, my electricity did not go off, and I'm happy about that. So I did send to my landlord's Edison bill thing. I did send the remittance coupon with the dollar stamp on the top right, because it was $1,800. That's a lot of money. And what else did I do? I asked them for their data officer, like, what are you doing with my information type of thing. But I haven't heard anything. But nevertheless, my fan is blowing on me right now, so I don't know if you hear any noise because it's kind of warm, a little bit windy, and it makes me mad because no sooner did I feel better, after having the flu, but then yesterday, the last day of the tabernacles, the Sukkot, Yahuwah's feast days. Some people are celebrating, on a different calendar because there's so many different calendars. But anyways, some of the people that I knew, they celebrated the Feast of Tabernacles this last week. And yesterday was the last day, the 8th day. And wouldn't you know, the day of tearing, all of a sudden I look up in the sky and there were the chemtrails. They're doing it this morning as well. Makes you mad because now it's going to get super windy and it's a possibility there might be some rain or overcast or something. But I do have a video on the chemtrails, so you can kind of look somewhere else to see that. But hey, I wanted to read this Federal Trade Commission that I saw in somebody, who was it? People's Remedy, their chat. Someone dropped this Federal Trade Commission. So I wanted to read it. Let's see how much I can read and get through without having a dry throat here. Federal Trade Commission. Staff guidelines on trade regulation rule concerning preservation of consumers' claims and defenses. Older in due course rule. We got to learn about this. What is that? So they give the staff these guidelines on the trade regulation rule concerning the preservation of consumers' claims and defenses. That would be us. So I did do that consumer claim. Hey, I sent in those remittance receipts or coupons with all the codes and everything. So let's see what up. Why is my energy still on? This is great. I guess because whenever you're doing, what do they call it? What is it called? When you're doing some type of a defense or contesting of your bill, they probably won't shut off your stuff right then anyways. But let me see. Here's the table of contents. Preface, text of the rule, purpose of the rule, mechanism of the rule, credit contracts, which must contain the notice. Oh, boom. Whoa, credit contracts. which must contain the notice. I have a feeling that when you sign up, wow, you have to contain a notice right there. Boom, you got to give them notice. Okay, so that's going to be a good section to read on page 8. Affected transactions, financing a sale, purchase money loans, general considerations 1, 2, specific purchase, 3, relation between creditor and seller, A, referrals, B, affiliation, placement of the notice. We got to know where that placement. An effective date, proposed amendment, and advisory opinions. All right, so let's see. Preface. Since 1945, consumer credit has grown substantially. One result has been a major commitment on the part of credit institutions to the retail consumer market. Credit has helped millions of families enjoy the fruits of our industrial society. This dramatic increase in consumer credit over the past 30 years has caused certain problems. Look, I know how to do this now. Yay! Let's see. I made it bigger. So evolving doctrines and principles of contract law have not kept pace with changing social needs. One such legal doctrine, which has worked to deprive consumers of the protection needed in credit sales, is the so-called holder in due course doctrine. Under this doctrine, the obligation to pay for goods or services is not conditioned upon the seller's corresponding duty to keep his promises. Typically, the circumstances are as follows: a consumer relying in good faith on what the seller has represented to be a product's characteristics, service warranty, etc., makes a purchase on credit terms. The consumer then finds the product unsatisfactory. Excuse me. It fails to measure up to the claims made on its behalf by the seller, or the seller refuses to provide promised maintenance. The consumer therefore seeks relief from his debt obligations, only to find that no relief is possible. His debt obligation, he is told, is not to the seller, but to a third party whose claim to payment is legally unrelated to any promises made about the product. The seller may, prior to the sale, have arranged to have the debt instrument held by someone other than himself. He may have sold the debt instrument at a discount after the purchase. Wow. Excuse me. From the consumer's point of view, the timing and means by which the transfer was effected are irrelevant. All right, hang on a second. I gotta get something to drink. Water. Otherwise, I'll be hearing my voice throughout this whole video. Lubrication. I need a drink. Thank you. Okay, so now what's it say? From the consumer's point of view, the timing and means by which the transfer was effected are irrelevant. He has been left without ready recourse. He must pay the full amount of his obligation. He has a product that yields less than its promised value, and he has been robbed of the only realistic leverage he possessed that might have forced the seller to provide satisfaction, his power to withhold payment. All right, so now what do we got here? On November 14th, 1975, the Federal Trade Commission addressed this problem by promulgating a final trade regulation rule concerning the preservation of consumers' claims and defenses. The rule, also sometimes called the holder in due course rule, becomes effective on May 14th, 1976. Remember that, holder in due course. That's a rule. The staff of the commission has received many inquiries about the interpretation and application of the rule. This pamphlet attempts to answer as many of these as possible. The analysis is informal and advisory in that it has not been formally reviewed or adopted by the Commission, nor does anything here alter or amend either the rule or the official statement of basis and purpose published with it. Nonetheless, staff of the Bureau of Consumer Protection believes this publication of staff views will help the public and that's good, and will facilitate and encourage compliance with the rule. Okay, here's the text of the rule. 433.1 definitions. Person, A, an individual, corporation, or any other business organization. B, consumer, that's you and I, a natural person who seeks to acquire goods or services for personal, family, or household use. That would be us. C, creditor, a person who in the ordinary course of business lends, purchase money, or finances the sale of goods or services to consumers on a deferred payment basis, provided such person is not acting for the purposes of a particular transaction in the capacity of a credit card issuer. D, purchase money loan, excuse me. A cash advance which is received by a consumer in return for a finance charge. Within the meaning of the Truth in Lending Act and Regulation Z. Wait, what's that? Purchase money loan. Oh, the cash advance which is received. Oh, there's that little dinger, ding, ding. Don't be dinging. Oh, okay. So purchase money loan, a cash advance. Oh, which is received by a consumer in return for a finance charge. Oh, within the meaning of the Truth in Lending Act and Regulation Z. Oh, which is applied in whole or substantial part to a purchase of goods or services from the seller who refers consumers to the creditor. What? What? Huh? Or two, is affiliated with the creditor by common control, contract, or business arrangement. Huh? Kickbacks? What's that all about? Okay, I gotta go up to the top over here. Financing a sale, extending credit to a, let me move my little self here. Consumer connection with a credit sale within the meaning of the Truth in Lending Act and Regulations. Okay, that's financing a sale. F, contract, any oral or written agreement, formal or informal, between a creditor and a seller, which contemplates, that's thinking deeply, or provides for cooperative or concerted activity in connection with the sale of goods or services to consumers or the financing thereof. G, business arrangement, any understanding? Yeah, meeting of the minds. Procedure, course of dealing or arrangement, formal or informal, between a creditor and a seller in connection with the sale of goods or services to consumers or the financing thereof. H, credit card issuer. I'm not one of those. A person, that's a corporation, who extends to cardholders the right to use a credit card in connection with purchases of goods or services. So that would be like Frontier Airlines, right? You know, when they offer you a credit card, but it's really being held by Chase Bank or, you know, Barclay or something. So I, consumer credit contract, any instrument which evidences or embodies a debt arising from a purchase money loan transaction or a finance sale as defined in paragraphs D and E. J, seller A person who, in the ordinary course of business, sells or leases goods or services to consumers. Okay, so 433.2, preservation of consumers' claims and defenses, unfair or deceptive acts or practices. Ooh, right here, yeah. In connection with any sale or lease of goods or services to consumers, us, in or affecting commerce as commerce is defined in the Federal Trade Commission Act, it is an unfair or deceptive act or practice within the meaning of Section 5 of that act for a seller directly or indirectly to A, take or receive a consumer credit contract which fails to contain the following provision in at least 10-point boldface type. Wow. Okay, so notice any holder of this consumer credit contract is subject to all claims and defenses which the debtor could assert against the seller of goods or services obtained pursuant hereto or with the proceeds hereof. Recovery hereunder by the debtor shall not exceed amounts paid by the debtor hereunder. So it has to be that big in your face. Or B, except as full or partial payment of such sale or lease, the proceeds of any purchase money loan as purchase money loan is defined herein, unless any consumer credit contract made in connection with such purchase money loan contains the following provisions in at least 10-point boldface type. Notice, here's a notice. Any holder of this consumer credit contract is subject to all claims and defenses which the debtor could assert against the seller of goods or services obtained with the proceeds hereof. Recovery hereunder by the debtor shall not exceed amounts paid by the debtor hereunder. Purpose of the rule. In adopting this rule, the Commission determined that it constitutes an unfair and deceptive practice within the meaning of Section 5 of the Federal Trade Commission Act 15 U.S.C. 45 for a seller in the course of financing a consumer purchase of goods or services to employ procedures which make the consumer's duty to pay independent of the seller's duty to fulfill his obligation. In the course of public proceedings of the rule, the Commission documented numerous cases where consumer purchase transactions were financed in such a way that the consumer was legally obligated to make full payment to a creditor despite breach of warranty. Whoa. Misrepresentation and even fraud on the part of the seller. Wow. Under ordinary contract law, the promises of the parties to a sale transaction are mutually dependent. So yeah, I trust that you're going to do your part. You trust that I'm going to do my part. It's mutually dependent upon you doing your part and I doing my part. That sounds good. A seller is entitled to payment provided he delivers what he promised to deliver. If the seller fails to deliver what was promised, the consumer's obligation to pay may be reduced or even eliminated. Yeah, that sounds good. However, it is possible for a seller to arrange credit terms for buyers which separate the consumer's legal duty to pay from the seller's legal duty to keep his promises. Boy, that is a tricky one. This separation of duties may be accomplished in 3 ways. First, the seller, the car dealership, or the house real estate place, may execute a credit contract with a buyer which contains a promissory note. In the event that the promissory note is assigned to a credit company, the credit company takes it free of any claim or defense which the buyer would have against the seller. Oh, this is true unless the buyer can prove that the credit company is acting in bad faith or with notice of actual seller misconduct. Second, if a local statute prohibits the use of such promissory notices in credit sale transaction, the seller may incorporate a written provision called a waiver of defenses in the text of an installment sales agreement. A waiver of defenses is the consumer's written agreement that his installment purchase contract may be treated like a promissory note in the event that it is sold or assigned to a credit company. Oh, wow. You're so tricky, man. Finally, a seller may arrange a direct loan for his buyer. Where a seller arranges a loan in this fashion, the lender is legally entitled to payment in full, whatever the seller may do or fail to do in the sales transaction, which accompanies the loan, and for which the loan is obtained in jurisdictions where efforts have been made to curtail the use of promissory notes and waivers of defense. The commission documented a significant increase in the use of arranged loans to accomplish the same end. All right, so the commission's rule is directed at all three of the above situations. It is designed to prevent the widespread use of credit terms, which compel consumers to pay a creditor, even if the seller's conduct would not entitle the seller to be paid. It is designed to preserve the consumer's legally sufficient claims and defenses so that they may be asserted to defeat or diminish the right of a creditor to be paid. Where a seller who arranges financing for a buyer fails to keep his side of the bargain. I wonder, how does a seller arrange financing for us, the buyer, fail to keep his side of the bargain? What would that be? That's a question. Mechanism of the rule. So the rule is designed to ensure that consumer credit contracts used in financing the retail purchase of consumer goods or services specifically preserve the consumer's rights against the seller. It requires sellers to include the following provision or notice in the text of any consumer credit contract which they execute with the buyer. And here it is. So here we go. Any holder of this consumer credit contract is subject to all claims and defenses which the debtor could assert against the seller of goods or services obtained pursuant hereto or with the proceeds hereof. Recovery hereunder by the debtor shall not exceed amounts paid by the debtor hereunder. In addition, if a seller arranges direct loan financing for his customers, the rule prohibits the seller from accepting the proceeds of the loan as payment for a sale, unless any loan contract signed by the buyer and the direct lender contains the following provision. So I guess we have to look in our contracts to see if any of this stuff is in bold writing here. Any holder of this consumer credit contract is subject to all claims and defenses which the debtor could assert against the seller of goods or services obtained with the proceeds hereof. Recovery hereunder by the debtor shall not exceed amounts paid by the debtor hereunder. For those consumer credit contracts in which the rule requires insertion of the specific contract provision or notice, the notice will become a part of the agreement between the consumer and the creditor. The required notice will be treated in the same manner as other written terms and conditions contained in the agreement. For this reason, where use of the notice is required, the notice must appear without qualification. The requirement that a contract contain the notice is not satisfied if the text of the notice is printed in a contract in conjunction with additional recitals which limit or restrict its application. Where the text of the notice is qualified by additional language, the contract fails to contain the required notice. I guess you got to see it just like that, all bold and separate from other things and not adding extra language. While the rule provides for two different notices, depending on whether or not the consumer credit contract involved is an installment sales agreement or a loan obligation, both notices mean the same thing. They protect the consumer's right to assert against the creditor any legally sufficient claim or defense against the seller. The creditor stands in the shoes of the seller. Wow. There is an important limitation on the creditor's liability, however. The wording of the notice includes the sentence, recovery hereunder by the debtor shall be limited to amounts paid by the debtor hereunder. This limits the consumer to a refund of monies paid under the contract in the event that an affirmative money recovery is sought. Huh. I'm looking for all the money sought. So that's a limitation on the creditor's liability. The wording of the notice includes the sentence, recovery hereunder by the debtor, all shall be limited. You know, when I had sent in my notices to the two different card dealer banks or whatever, I didn't get the whole contract. I mean, it was such tiny little writing. I'm gonna have to like blow it up to try to even read it, but it looked like they only put like one page in there. Like they didn't put the whole entire contract. So they could be hiding the fact that they didn't have this written on their deal. All right, so let's see, let's read some more. In other words, the consumer, that would be us, may assert by way of claim or defense a right not to pay all or part of the outstanding balance owed the creditor under the contract, but the consumer will not be entitled to receive from the creditor an affirmative recovery which exceeds the amount of money the consumer has paid in. Oh. So if you pay like $28,000 for your car, I guess you can't maybe ask for more than that. What about if you had like late fees or something? I don't know. So thus, if a seller's conduct gives rise to damages, hey, in an amount exceeding the amounts paid under the contract, the consumer may sue to liquidate the unpaid balance owed to the creditor and to recover the amounts paid under the contract, or to defend in a creditor action to collect unpaid balance. The consumer may not assert against the creditor any rights he might have against the seller for additional consequential damages and the like. The same situation would exist where a seller's conduct would, as a matter of law, entitle a buyer to rescission and restitution. The consumer, relying on the required notice, could initiate proceedings to invalidate the credit contract and receive a return of monies paid on account. If a down payment were made under the credit contract, the consumer could recover the down payment as well as other payments. Recovery of a down payment would be possible under many installment sales contracts. It would not be possible in situations where a direct loan contract is used. A direct loan contract is used because the down payment would not have been made pursuant to the loan contract. Oh, yeah, okay, because like if you went and bought a car and you put another car down, like 5,000, they gave you $5,000 towards your next car. I guess you couldn't get that 5,000 because that's recovery of a down payment would be possible under many installment sales contracts. It would not be possible in situations where a direct loan contract is used. Huh. Because the down payment would not have been made pursuant to, oh, yeah. So the direct loan would be to like Ford Finance or whatever. But if you were at Ford, you know, they give those guys $5,000 or a trade-in car or whatever. That other, it's not even in the loan. So, okay. So now the limitation on affirmative recovery. Let me scroll. The limitation on affirmative recovery does not eliminate any other rights the consumer may have as a matter of local, state, or federal statute. The words recovery hereunder, which appear in the text of the notice, refer specifically to recovery under the notice. If a larger affirmative recovery is available against a creditor as a matter of state law, the consumer would retain this right. Oh. It is also important to note that the rule does not create new rights or defenses. The words claims and defenses, which must appear in the notice, are not given any special definition by the Commission. The phrase simply incorporates those things which, as a matter of other applicable law, constitute legally sufficient claims and defenses in a sales transaction. Appropriate statutes, decisions, and rules in each jurisdiction will control, and the pertinent rule of law and equity, rules of law and equity, including rules of evidence, procedure, and statutes of limitation. Darn it, statutes of limitations now will continue to apply. But wait, I thought I fraud vitiates everything. So, for example, where a product is sold as is, well, duh, and there could be no warranty claim or defense, the rule would not create one. Where a local jurisdiction has a 2-year statute of limitations on contract claims, darn it, shoot, 2-year, darn. And defenses would be extinguished after 2 years. Oh, man. Where a local jurisdiction imposes a rule analogous to latches or equitable estoppel, consumer claims and defenses would continue to be subject to such limitation, and the consumer would have a duty to notify the potential defendant of his contention within a reasonable time. Gosh, you gotta stay on top of this stuff. The rule does not apply to all claims or defenses connected with the transaction, whether in tort or contract. When under state law, a consumer would have a tort claim against the seller that would defeat a seller's right to further payments or allow the consumer to recover affirmatively. This claim is preserved against the holder. This is, of course, subject to the limitation of recovery under this rule to the amounts paid in. It is also possible for a consumer to have a claim or defense against a seller because of a separate transaction. The provision required by the rule would not allow him to assert such a claim or defense against the holder. The holder's obligations are limited to those arising from the transaction which he finances. The vast majority of cases, in the staff's opinion, will involve a limited right of set-off against the unpaid balance. Most sellers do not do business in a way that creates a right to rescission or significant consequential damages. It is probable that the vast majority of disputes between buyers and sellers will be settled by means of informal mechanisms. Yeah, they're probably going to be going to the, what do they call that thing? It starts with an A. What do they call that? I don't remember. Where you have your in-house people decide. You don't go to court. I can't think of what's called. This is the case in most seller-buyer conflicts today. While the rule preserves and protects the consumer's legal right to assert claims and defenses, it does not compel unjustified reliance on the legal system in individual cases and will not promote frivolous or unsubstantiated claims. Credit contracts which must contain the notice. The rule does not apply to all credit instruments. The notice must appear in written obligations defined as consumer credit contracts in the rule. The definition includes any written instrument which, under the Truth in Lending Act and Regulation Z of the Federal Reserve Board, constitutes a consumer credit contract, and which is used to finance a sale, as that term is defined in the rule, or number 2, connection with a purchase money loan, as that term is defined in the rule. So affected transactions. The initial question is whether a sale constitutes a consumer transaction at all. What? What? The rule defines the term consumer to mean a natural person who seeks or requires goods or services for personal, family, or household use. That's us. And covers sales of all kinds of consumer goods or services for personal, family, or household use. Purchases of appliances, automobiles, furniture, food, and any other products sold to individuals for non-commercial purposes are covered. Services such as home improvement contracting, vocational training, employment counseling, or placement, health spa membership, and similar agreements made with individuals for non-commercial purposes are covered. Sales of goods or services for commercial use are not covered by the rule. This includes the purchase of equipment for agricultural production because such production is a commercial activity within the meaning of the rule. Nor does the rule apply when the purchase is made by or for an organization rather than a natural person. Finally, only purchases of goods and services are covered by the rule. Sales of interest in real property are unaffected, as are purchases of commodities or securities. Sales of interests in real property are unaffected, as are purchases of commodities or securities. However, the mere fact that a security interest in real property is taken does not mean that the sales transaction does not involve consumer goods or services. For example, home improvement contracting, which does constitute a sale of goods or services, is often financed by credit secured by real property. Right, they could put a lien on your house. Okay, so they blocked off this other part. Wow, what is that? I'll skip all that, but you can probably read it. So public utility services are not a, what? Wait a minute. Public utility services are not affected by the rule? What? What? That's not good news. Finally, only those leases which constitute credit sale agreements under Regulation Z are affected by rule. Regulation Z applies to those leases where consumer contracts to pay a sum substantially equivalent to or greater than the value of the property leased and receives an option to become the owner of the property for no consideration or a nominal consideration. Regulation Z. I wonder if that has anything to do with timeshares or something. I don't know. The first 2 sentences of this paragraph have been stricken because the rule applies regardless of transaction amount, as noted in the 2021 staff note. Oh, I got you. Thank you. I don't know if I like that sentence with the public utility services are not affected by the rule. I don't know what that means. What do you mean they're not affected by the rule? What does that mean? Is that a good thing or a bad thing? On the bottom of page 9 here, I'm going to have to pause this because I got to go somewhere, but I'll be back. I shall return. I'm going to have to stop. I'm going to have to do I'm gonna have to do a part 2 because I have to leave for a little bit. But we'll be back.